Go ahead. I'll let you address mine before I give you the date, I guess.
Thank you. Before I kind of address the substantive bond in this matter, I do want to address kind of clerical error in another case. The court may see that there's a case out of 1482, 25203, or, oh, sorry. Okay, actually, you know what? I'll save that for the end if it comes up. Just because it looks like she's being held on another matter for a higher bond than she actually has, at least in the system that I.
Out of my court.
Oh, sorry, 1482.
So
Oh,
what
so,
would you want me to do with that?
well, in case that was part of your consideration for.
Oh, I see. You
Apology.
don't want me to change it.
No, I do. Oh, so as far as
Well,
this
but I
matters,
won't.
yeah.
You can go to Judge Barr, but go ahead.
So as far as this court is concerned, Ms. McDowell is being held on a $50,000 bond. This is the result of an emergency bond motion and the court's order in response to that motion, that hearing on the June 16th. Circumstances have changed since that hearing. My understanding is at that time, the complaining witness was residing very close to where Ms. McDowell resides.
Have the circumstances changed to the extent that the allegation of a knife to the body or hand of a 15-year-old has changed?
Yes.
Well, the charged alleged conduct in the police report, as far as that report, which we have not had any substantive hearings on the merits on that matter, but the report hasn't changed to my knowledge. But we have stood mute on that matter.
Yeah, screenshots.
Yeah, and we do. I mean, we are gathering discovery on the matter, and I would say in terms of the kind of concerns related to bond about Ms. McDowell being close to the complaining witness, I do believe that the complaining witness, I understand, is residing in Detroit with her grandmother. She no longer resides next door to Ms. McDowell.
I got her moved.
Ms. McDowell also she's been in custody for 15 days on this matter. She is willing to go on GPS tether. She has, support in the court. She has a coworker and friend who is here today. Her sister was planning to be here today, but was not able to. I do think that additionally, the hardship of her being in custody is something I request the court take into account. She's concerned about the security of her residence. She's been informed that there has been potential vandalism and potential people breaking into her home while she's been out. No one else is officially residing there. Ms. McDowell there's no allegations of Ms. McDowell trying to contact the complaining witness. There's no allegations that she's been making jail calls. She has no intention of contacting the complaining witness in this case, and she understands the seriousness of that. And so I do believe that the being held in custody on a $50,000 bond is excessive in this matter. We can address. Yeah, okay.
You're saying the bond I set was excessive?
Well, at present, given the current circumstances, which have changed, the information you had before you then is not the same as the information as it is now. Of course, I would not question the court's judgment. But specifically, because of the potential hardship to her and the concerns about her home, the concerns about the fact that she is no longer anywhere near, she won't be anywhere near the complaining witness. And, she has already been in custody for 15 days. The final matter is, she works as a supervisor at her workplace. She's been there for 5.5 years. She is very concerned about, her job. And so I would request, that she be able to be released to work. I understand that one of the release conditions includes a GPS tether. She's happy to go on a GPS tether and follow any conditions this court thinks are appropriate for her to be released. But if the court would consider, her.
Where are the other two children?
My kids were left at home, attended for 2.5 weeks, sir. And I literally moved my kids to Detroit to my mom. They are safe now, and I did sign my rights over, sir. But my children were left home, attended for 2.5 weeks. I sent cash up money to them.
Well, this
it
is
was a
Miss
safety
McDowell.
concern.
I don't think we want to address anything with the children right now, other than the fact that they're residing with their
I
grandmother.
got the move. I
Um,
just want you to know
yes.
that, sir.
And Miss McDowell, all three children are living with the grandmother.
And I've been working from my job, my jail cell for 3.5 hours a week because I had to still provide for my children because I knew that they were home left attended. I have that on recording on the jail cell as well. With the CPS lady, her name is Tiffany Avery, sir.
And to be clear, this is not a conversation involving the children. It was just with,
And I've never been accused of
Yes.
anything violent. The other accused, the malicious property destruction, I have a $10 bond, sir. And that is taken care of. And you prosecuted her rapist and that was the
Ms.
dad.
McDowell, I think if you can just hold off on saying, I think we'll address anything.
I just wanted to speak
Yes.
up for myself, sir, because I'm not a criminal, sir, and I really, really do need to go to work, sir. I've exhausted my funds and I've been taking care of my children for 2.5 weeks. I didn't make contact, but I do know that they were home by themselves. And it just was discovered. And the CPS worker is going to be providing those information as well. I'm sorry, sir.
That is all, Your Honor.
Your Honor, if the court's familiar with this case, I'm not gonna re-exhaust the motion that we filed. The only thing that I see that's changed since last hearing is that the children have been placed with that grandmother in Detroit. The facts of this case still stand that she is being stabbing her daughter with a butter knife so severely that her daughter needed stitches in her hand. I mean, I have severe concerns, and not only that, she threatened to kill her daughter, and her daughter was so afraid to contact police. She had to have text a friend to call police because she was so afraid. I mean, I have great concerns, even if she is released, for her children's safety. And this is a very significant case. And I believe in our bond form, our original request was 100,000, 50,000, as set by the court is appropriate in this case and should remain as set.
Your Honor, if I may address that, there is no history of violent conduct between Ms. McDowell and the complaining witness in this case. The basis of the statements that were just made by the people are entirely the police report in this case.
And
Again,
her stitches.
Well, the basis of the allegation that Ms. McDowell is the cause of the injury is based on the police report. That has not been addressed on the merits. And again, there's no history of legal issues or reports of violence between Ms. McDowell and her children. I would say, I don't believe, I would like the court to consider the gravity of holding her in custody on the basis of just the police report at this stage of the case, with no allegations that she has violated her.
Telling me it's wrong that the child was at the hospital getting stitches, counsel, and that's what I should consider?
I want the court to consider the fact that that Ms. McDowell has stood mute. The court has entered an octave.
I understand all of
Yes.
that, but you're asking me to consider her hardship and saying that there are certain things that may be objective in that police report that I shouldn't consider that.
I would like the court to consider the fact that Ms. McDowell is no longer going to be anywhere near that child. So if there is a concern about the possibility that that injury may have been caused by Ms. McDowell, which we deny, that would be addressed by that fact. In addition to the fact that there would be a GPS tether as part of her bond conditions.
Same
And
teenager.
Your Honor, I did also want to make the record clear. She does have
And
a
have
previous
police
conviction
report.
for domestic violence from 2018. She also has a previous conviction for larceny from 2020, and she also has the pending case of the MDOP with another domestic relationship. So I mean, I do have concerns. She does have an assault history, and given this case, I have concerns that it's escalating from what her previous history is.
Your Honor, none of these cases involve Ms. McDowell's children.
Yeah, but you said she didn't have a violent history. She got a DV conviction. Motion for bond reduction is denied. Bond will continue.
And Your Honor, did we set a date?
I don't know, July 3rd, 1 week out.